Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I wanted to provide an update to my Section 74 application, and I say my Section 74 application because I'm one of the people involved, but there's a number of litigants here, and I don't mean to denigrate them or their counsel. Just I think of it as my Section 74 application because I'm one of the people involved, and it's me doing the video. So anyway, to explain what's going on here is a little bit complicated. As you may know, the Registrar of Firearms sent out a letter saying that certain registration certificates were automatically nullified. And I brought a challenge to this saying, no, they're not automatically nullified. That's not a thing. Now, the counsel for the registrar brought an application to strike out my application, basically saying there's no jurisdiction. Now, I wanted to call evidence on that point and say, let me provide some evidence to show that the court does have jurisdiction. And the opposing counsel said, we oppose that. We just want this to be heard solely on the letter from the registrar. So we had a first initial hearing to determine whether or not we could have evidence heard on the question of jurisdiction to determine if the court can hear the rest of the case. If you're a little confused, my apologies. This is a bit of a confusing process, but we're still on the jurisdiction question, which is the same question that has been at issue in several other cases I've covered on this same topic. But what's happened is this is an application for us to be able to call evidence and to determine if the other side possibly also has to call evidence. Now, I'm going to go through this case with you, and I'm going to offer some explanation and some commentary, but because this is an ongoing case before the court, and because it involves me personally, my commentary has to be kept to certain, things. I can't give away, anything here, and it would be improper for me to comment about the judge, I think. And that doesn't mean that that I'm holding back some sort of negative commentary. Don't read that in here. It's just, I quite agree with this decision. I think it's well reasoned, but that's about as far as I'm going to go in terms of discussing the reasoning on this particular case for various reasons. So this will be more of an explanation of what's happening rather than anything else. Apologies, but that's sort of what I got to do here. So let's jump in here. So the applicants in these cases have all filed applications with this court for a Section 74 hearing under the Firearms Act. On September 25th, 2020, Assistant Chief Judge Bodnarek appointed me to case manage the Edmonton firearms cases. There are a number of similar applications being made across the province and indeed across Canada. There's tons of these on the go. The respondent, Government of Canada, the GOC, applies to strike all the applicants' motions for a hearing, arguing that the court lacks jurisdiction on the basis that the letter informing the applicants of the enactment of an order in council does not constitute a decision of the registrar for the purposes of Section 74 of the Firearms Act. At issue in this decision is whether or not I can, or rather should, decide the GOC's motion to strike in the absence of any further evidence. It is the GOC's position that the record before me is sufficient to decide the jurisdictional question. The applicants, here responding to the GOC's motion to strike, argue that they should be allowed to call evidence on the question of jurisdiction. So essentially, what the Government of Canada is arguing is that the letter itself is enough, and that's all the court should listen to. Now, the letter comes essentially from the GOC. It comes from the registrar. So essentially, if that position was accepted by the court, the only evidence would be essentially a statement from the Government of Canada. You can see why I want to call some evidence of my own. For the reasons that follow, I am of the view that the record before me is so deficient that it would not be just or fair to decide the jurisdiction question. In my view, it is in the best interests of justice, the GOC, and the applicants that the jurisdiction question be settled. And that makes sense, right? We all want an answer to this question. However, there must be an adequate record for such a decision. I am not going to read you the list of cases cited, but you can see it scrolling on your screen here. There's quite a number of them. This isn't sort of anything significant, but you can see that a number of these are my past round there, the Runkle cases, basically. So this is not my first time contesting such an issue, and in fact, the last time I did, I made significant case law on the topic. Anyway, carrying on. Background to this application. On May 1st, 2020, the Governor and Council passed a regulation, and that's the citation to it, pursuant to the sections 84 sub 1 and 117.15 of the Criminal Code of Canada. And this regulation reclassified a number of formerly non-restricted and restricted firearms. As of May 1st, 2020, those firearms were now classified as prohibited weapons. Properly prohibited firearms, but that's a very common interchange. Subsequently, I understand that a letter was sent to the affected firearm owners. 8 of those owners are now before me. Hereafter, I will collectively refer to them as the applicants. And one of those applicants is me. The letter is dated July 20th, 2020. Each letter is addressed to the applicant and cites their license number at the top right-hand corner of the letter. The letter advises of the change in the regulations and also advises of the order declaring an amnesty period, which they list, which protects from criminal liability those firearm owners who were in lawful possession of the now prohibited firearms on the date the classification regulations came into force. The letter states, certain restricted firearms which were registered to you have been affected by the recent regulatory amendments. These firearms, listed below, are now classified as prohibited, and the previous registration certificates are automatically nullified and are therefore no longer valid, but should be retained as a historical registration record. Now, my view is that there is no such thing as automatically nullified, but that is going to be an issue for this court to decide later down the road. Right now, we're not there yet. The letter then has a box with the heading registration certificate number of the affected firearm, the make, the type, the serial number, and the firearm's identification number, and the requisite information below each heading for the affected firearm. Under the registration certificate number, there is, in brackets, the superscript, no longer valid. Thereafter, the letter provides some information derived from the classification regulations on what the firearm's owner can do with the now prohibited firearm. The letter states the following. The government has publicly announced that it intends to implement a buyback program for the newly prohibited firearms. More information on the buyback program will be available at a later date. Owners of newly prohibited firearms are to keep them securely stored in accordance with the previous classification. They cannot be sold or imported. They may only be transported under limited circumstances. They cannot legally be used for hunting unless allowed through the amnesty order. There are provisions for certain hunters, but as I've mentioned in another video, those are really not great provisions. I would not recommend using them. They cannot be used for sport shooting, either at a range or elsewhere. What are your options now? Wait for further instructions to participate in the buyback program. Have your firearm deactivated by an approved firearms business and advise the registrar of firearms once completed. Legally export your firearm, in which case you can engage businesses with the proper firearms license privilege. Once exported, you are requested to advise the registrar of firearms. The letter closes with Registrar of Firearms on the signature line. The Firearms Act gives the Registrar of Firearms the power to refuse to issue a license, authorization, or a certificate of registration. The Firearms Act also gives the Registrar of Firearms the power to revoke a license, authorization, or a certificate of registration. Section 72 sets out the prescribed form which the registrar must use to issue a refusal or revocation. And these notices, of course, did not come via a Section 72 prescribed form. All of the applicants have filed a form with the Provincial Court of Alberta requesting a hearing before a provincial court judge pursuant to Section 74 of the Firearms Act. The section reads as follows. I'm not going to go through all of the legislation, just the sort of key bits here. Reference to judge of refusal to issue a revocation, etc. Subject to subsection 2, where a chief firearms officer or the registrar refuses to issue or revokes a license, registration certificate, authorization to transport, authorization to export, or authorization to import. And skipping over a little bit, the applicant for or holder of the license, registration certificate, authorization, or approval may refer the matter to a provincial court judge in the territorial division in which the applicant or holder resides. Sections 75 and 76 set out the provisions regarding the hearing and the scope of decision-making power of a judge under this section. So I'm skipping over to the evidence portion here because that's bolded and is key here. At the hearing of the reference, the provincial court judge shall hear all relevant evidence presented by or on behalf of the chief firearms officer, registrar, or provincial minister and the applicant or holder. And skipping ahead a little bit further, the Firearms Act, unlike the Criminal Code, sets out few details on the procedure a Section 74 hearing should follow. Given that statutory vacuum, the procedures in these cases are to be determined by references to the provisions of the Firearms Act, the Provincial Court Act, and the Alberta Rules of Court. So essentially, because the Firearms Act says almost nothing about how these hearings take place. And so the court is going to have to look beyond that and look at other statutes that govern how hearings generally take place in order to apply that. So the Provincial Court Act states as follows. Rules of court, practice and procedure shall be provided, or shall be as provided in this act and the regulations. Where this act or the regulations do not provide for a specific practice or procedure that is necessary to ensure an expeditious and inexpensive resolution of a matter before the court may apply the Alberta Rules of Court and modify the Alberta Rules of Court as needed. What power then does the Rules of Court give to a judge to dismiss a claim summarily? Two parts of the Rules of Court are relevant. They are as follows, and I recognize this is probably dry as toast, but unfortunately, this is one of the things you got to do as a lawyer is sometimes dig through the rules, because just as if you're playing a board game, knowing the rules is pretty critical. So that's what's going on here is we're trying to figure out what the rules of this hearing are so that then they can be applied and then we can decide how it continues. So significant deficiencies in claims, court options to deal with significant deficiencies. If the circumstances warrant and a condition under Subrule 2 applies, the court may order one or more of the following, and this is 3.68 sub 1. So A, strike out any part of a claim or defense, commencement document or pleading be amended or set aside, judgment or an order be entered, or an application, action, or proceeding be stayed. The conditions for the order are one or more of the following. A, the court has no jurisdiction. So that seems to be applicable here because that is what that's what the government of Canada is arguing. B, a commencement document or pleading discloses no reasonable claim or defense to a claim. C, a commencement document or pleading is frivolous, irrelevant, or improper. D, a commencement document or pleading constitutes an abusive process. E, an irregularity in a commencement document or pleading is so prejudicial to the claim that it is sufficient to defeat the claim. No evidence may be submitted on an application made on the basis of the condition set out in Subrule 2 sub B. And just going back, that is a commencement document or pleading discloses no reasonable claim or defense to a claim. So an example of that would be, for instance, if I decided to sue, let's go with Justin Trudeau for, something ridiculous that, he using, his psychic powers moved the moon and that this is, causing me distress. Something, absolutely ludicrous. That would be no reasonable claim. Or if I, was arguing that he owes me money, but the theory by which he owes me money is not one that's known to the law or makes any sense, then it could be struck on that basis. So that's what 2B applies to, but it's not a no jurisdiction issue. No jurisdiction is 2A. That's a different section. There's also resolving claims at full trial, which allows for orders that dispose of all or part of a claim. I'm going to skip over that because it's not as critical here. Two things are immediately apparent on the reading of both sets of provisions. Under Rule 3.68, it is clear that the court can have some evidence before it in deciding to strike all or part of a claim under this rule. Subsection 3.682 sub B explicitly states no evidence may be submitted on an application made on the basis of the condition set out in Subrule 2 sub B. This section precludes the calling or hearing of evidence on a motion to strike on the basis that the commencement document discloses no reasonable claim. A reasonable reading of the section then leads me to conclude that the rules permit evidence to be called on Rule 3.68 sub 1 sub A, sub C, sub D, and sub E. I note that Rule 3.68 sub 1 sub A deals with an application to strike for want of jurisdiction, precisely the issue before me in this case. So what the judge is indicating here is that because it says there are 5 things, and on the second one you can't call any evidence, that implies that you can on all of the others, right? That's just the plain interpretation there. So that's what the judge is indicating. In my view, a plain reading of Rule 3.68 permits the calling of evidence, and only on one aspect of the Government of Canada's argument does the rule preclude the calling of evidence in a motion to strike hearing. Indeed, in Niss and Stenberg, the Alberta Court of Appeal stated that evidence could be called on a motion to strike per Rule 3.68 sub 2 sub A at paragraph 21. The TELUS employee's application to strike the appellant's statement of claim against them was not made on the basis that the pleading discloses no reasonable claim. It was made on the basis that the court has no jurisdiction because the dispute is within the sole jurisdiction of the arbitrator under the terms of the collective agreement between TELUS and the union, Rule 3.68 sub 2 sub A. Evidence can be admitted on such an application, and the court will not assume that every fact pleaded is true. The statement of claim should only be struck if it is plain and obvious that the court has no jurisdiction. This can only be determined by evidence of all the surrounding facts. Subsection 2 presupposes either an agreement of the parties on the facts, or that the facts are not an issue in relation to the question of law to be decided. I do not have any agreement on what the facts are here. Indeed, quite the opposite. I will remark that the record I have before me is anorexic and sliding into skeletal. The second rule applicable to this application is Rule 7.1, the summary judgment rule. This rule plainly is in place to inject efficiency and economy into judicial proceedings and to avoid the time, effort, and expense of a full trial if possible. Again, a plain reading of the rule, absent any judicial exegesis from the case law, would reasonably lead to the conclusion that the record on which a summary judgment is based must be factually sufficient and uncontroversial. In Hriniak and Maudlin, the Supreme Court of Canada expanded the applicability of summary judgments as a tool to facilitate quick, efficient, accessible justice. Karakatsanis said, I conclude that summary judgment rules must be interpreted broadly, favoring proportionality and fair access to the affordable, timely, and just adjudication of claims. Hriniak was considered by the Alberta Court of Appeal in Ware-Jones Technical Services Incorporated and Purolator Courier Limited. The Court of Appeal helpfully summarized the principles applicable when applying the summary judgment rules at paragraph 47. The proper approach to summary dispositions, based on the Hriniak test, should follow the core principles relating to summary dispositions, the standard of proof, the record, and fairness. The test must be predictable, consistent, and fair to both parties. The procedure and the outcome must be just, appropriate, and reasonable. The key considerations are: A. Having regard to the state of the record and the issues, is it possible to fairly resolve the dispute on a summary basis, or do uncertainties in the facts, the record, or the law reveal a genuine issue requiring a trial? Has the moving party met the burden on it to show that there is either no merit or no defense, and that there is no genuine issue requiring a trial? At a threshold level, the facts of the case must be proven on a balance of probabilities, or the application will fail. But mere establishment of the facts to that standard is not a proxy for summary adjudication. If the moving party has met its burden, the resisting party must put its best foot forward and demonstrate from the record that there is a genuine issue requiring a trial. This can occur by challenging the moving party's case, by identifying a positive defense, by showing that a fair and just summary disposition is not realistic, or by otherwise demonstrating that there is a genuine issue requiring a trial. If there is a genuine issue requiring a trial, summary disposition is not available. In any event, the presiding judge must be left with sufficient confidence in the state of the record such that he or she is prepared to exercise the judicial discretion to summarily resolve the dispute. Now, summary resolution here basically ends the case. And so what the court in that previous decision is saying is, amongst other things, you need enough of a record that the judge can be confident to basically end the case at that point and to say, you know, this case is done, it's over. Because if there's still issues left to be determined, then that creates an unfair situation. So that's kind of a summary of that. The record. A Section 74 firearms hearing is initiated by the party filing a form in provincial court. That has been done here. Attached to some, but not all of the Section 74 notices is the letter described above from the Registrar of Firearms. The applicants and the bunch of names have all attached the letter. However, one letter is so poor a copy as to be largely illegible. Most importantly, the boxes describing the firearm registration certificate, model number, etc. are effectively blank. Another application has been mislaid post-filing and have no information what, if any, attachments it might have. So that's an issue at the courthouse. Sometimes it happens. Mr. Runkle, that's me, advised in this hearing that he has lost the letter and would like the Government of Canada's assistance in securing another copy. That's since happened. Most of the applicants have indicated on the form that they are seeking a reference to a provincial court judge for review of the decision of the Registrar/Chief Firearms Officer and specifically indicate, by checking a box, that the decision is the revocation of a registration certificate, Section 71 of the Firearms Act. As noted above, one form is mislaid. Mr. Runkle and another person also indicate on their reference form that the revocation letter received by them is statutorily deficient. The Government of Canada has filed nothing on the applications that could be construed as facts for the purpose of making a summary judgment. In my view, the pleadings, upon which I am supposed to make factual determinations in making a summary judgment, are so scant and deficient that it would be, in my view, manifestly unjust to dismiss the applications. The common thread in the applicant's argument is that the letter constitutes a decision by the registrar, specifically a revocation, and that this is a basis for the applicant's request for a Section 74 hearing. The Government of Canada maintains that this letter is information only, specifically advising the applicants of the effect of the change in the classification regulations. Both the applicants and the Government of Canada refer me to the decision in Gardner. In that case, Justice Fitzpatrick reviewed the decision of the Ontario Court of Justice, where that court determined that it did not have jurisdiction to conduct a Section 74 hearing. Justice Fitzpatrick was sitting in his capacity as summary conviction appeal judge. At issue was a letter sent to Mr. Gardner concerning his firearm. At the hearing in the Court of Justice, the court heard evidence from the registrar by way of affidavit and made findings of fact. The court did not permit Mr. Gardner to call evidence, clearly in contravention of Section 75 sub 2, which states, at the hearing of the reference, the provincial court judge shall hear all relevant evidence presented by or on behalf of the Chief Firearms Officer, registrar, or provincial minister and the applicant or holder. On appeal, Justice Fitzpatrick noted that this was a denial of natural justice to make a decision at a hearing where only one side is permitted to give evidence. Justice Fitzpatrick ordered that a new Section 74 hearing be heard in the Ontario Court of Justice. A number of observations made in this judgment are instructive. The justice remarked that the pure legal issue of whether or not the registrar's letter could constitute a revocation should have been considered in isolation at paragraph 19. This matter arises as a result of a letter received by Mr. Gardner on November 17, 2011. It seems to me that in deciding if the court had jurisdiction at first instance or not, the only issue to be decided was whether or not this letter constituted a written confirmation of the decision of the registrar to revoke the registration of the rifle. Justice Fitzpatrick noted that in coming to his decision, the OCJ judge relied on the untested affidavit evidence of a number of witnesses for the registrar. So one side gets to present evidence, the other side doesn't get to cross-examine or anything like that, and their evidence just goes in. Justice Fitzpatrick also commented on the paucity of procedural provisions in the Firearms Act for a Section 74 hearing. Justice Fitzpatrick specifically notes that the right to call evidence according by the section should not easily be dismissed, paragraph 22. The scheme under the Act creates a summary procedure for firearms owners to challenge administrative decisions. In my view, the requirement in Section 75 sub 2 for a court hearing, a reference to hear all relevant evidence, indicates Parliament's direction that despite the summary nature of these hearings, rights of license holders and others encompassed by Section 74 are not to be summarily dismissed without those persons being given the opportunity to place all relevant evidence before the court. In specifying this right to call evidence, It cannot be circumvented without some other express statement in the legislation or in the rules of court to permit an application of this nature to be disposed of without the holder being permitted to call evidence. While questions of jurisdiction are always germane to any proceeding before the court, where there is a statutory provision using mandatory language, such as the language here, this right cannot be so easily dismissed. And at paragraph 29, Justice Fitzpatrick notes, occasionally the summary procedure that Parliament puts in place to attempt to expedite access to justice cannot contemplate all manner in which matters will be placed before the court. In this case, an alternate procedure of having a preliminary motion without evidence save and accept the letter may have allowed the Ontario court to determine the issue of jurisdiction without unfairness to either party. As noted above, the record before me is skeletal. A quick review of the Canada Evidence Act discloses no provisions that would make the letter admissible in evidence by operation of that act. The Firearms Act has no provision which renders this letter admissible in evidence. The applicant's reliance on the letter as evidence that a decision has been made in relation to their firearms and certificates of registration is not implicitly an admission of all the facts contained in the letter, nor is it an admission about the legal character of the decision or information contained in the letter. So essentially what this is saying is that those letters end up before the court just to say, here's the decision that we want to challenge. And, this says that a decision was made and that we're trying to contest it. But that doesn't mean that it's an admission of anything else in the letter, or even that we think that, the other statements in the letter are true necessarily. So that's essentially what the court is saying, is that it's admitted for, certain limited purposes, but it's not a way to sort of sneak evidence in beyond that. Hriniak enjoins me to use the summary judgment powers of our rules of court in the name of judicial economy, access to justice, and fairness. Ware makes clear, however, that the record I have before me must be sufficient to make that summary judgment. Gardner also enjoins me not to lightly and summarily take away the right to a Section 74 hearing, which Parliament has accorded firearms owners. Speaking just personally, I really like that paragraph because that is a big issue with respect to some past cases. So, we need a right to a hearing. That's one of the big issues here is, can we be heard in provincial court or, at all in some cases? I've reviewed a number of other cases concerning Firearms Act applications in response to the changes in the classifications regulations. Judge Gorman's decision in Newfoundland was interesting, but the factual basis upon which he based his legal conclusions is, in my view, unclear. The decision in Fritz is likewise devoid of detail on what record the court was proceeding in. In Wyville, the court based its decision on 2 days of hearings during which Mr. Wyville testified. In the Gardner case, cited above by both the Government of Canada and the applicants, the court of first instance heard evidence by way of affidavit from the registrar. I have read Judge Fradham's decision in Stark. I note that it contains information about when Mr. Stark received 3 certificates of registration in relation to his 3 firearms affected by the changes in the classification regulation. Plainly, Judge Fradham had information before him regarding Mr. Stark's ownership and registration of this firearm that I do not have in relation to the applicants before me. I conclude that Judge Fradham had other information before him not referred to in his decision. The Stark decision and the other decisions referred to above do not assist me in deciding whether or not the record I have is sufficient to decide the jurisdiction question. The judges in each of those cases obviously felt the record before them was sufficient, or there was an agreement between the parties on the facts and the legal question to be decided, which is not reflected in the text of the decisions. Conclusion. In my view, the record before me is at this time deficient. As such, I dismiss the Government of Canada's application to strike the applications. So the Section 74 is still going ahead. But there's a little more here. In my view, it would be prudent to have what is essentially a trial of an issue regarding the jurisdictional question. It is a legal problem which is common to all the applications before me. Resolving the jurisdictional issue would, in my view, be expedient and fair. I propose that we set a date in the future to argue this issue with deadlines for the filing of affidavits and argument. As well, 3 of the applications are deficient in that they do not have the letters which constitute the challenge decision of the registrar on the court file. Consequently, I'm making the following directions. 1. that Mr. Runkle and other people refile the letter they received. If Mr. Runkle cannot locate this letter, then I would ask the Government of Canada to assist, if possible, to secure copies from the registrar to perfect the notice of hearing that they have filed. That's all. I've got a copy. It's going to get filed. That the Government of Canada and the applicants file whatever affidavit evidence they wish me to consider on the jurisdictional question. We will then set further dates for hearing argument, or if necessary, applications to cross-examine on an affidavit. I will remark that both Rule 3.68 and 7.1 contemplate a sufficient record upon which a court can decide a jurisdictional question. Insofar as it is possible, I urge counsel for the applicants and the self-represented applicants and counsel for the Government of Canada to put together some form of agreed statement of facts, which would at least simplify and focus the facts on the jurisdictional issue which I have to determine. I realize that the Government of Canada and the applicants are not ad idem about the legal character of the letter or its genesis. That said, the parties should come to some agreement about the non-contentious facts in this case, so we can focus our time and effort on what matters. So essentially, the court is saying, please narrow this a little bit, because otherwise this is going to take forever. And that is certainly a fair comment. We all want efficient and economic processes. So yeah, as I said, not going to comment too much on, the decision here. But I like the result. That's the thing here. What this essentially is I want to bring some evidence, and I still want to bring some evidence as to show that this is a decision, to show that that the court has jurisdiction over this. So, in my view, that needed evidence to be decided, and the court has agreed. So that's going to be the next step. Is there's going to be a trial with evidence heard, likely from both sides, just on the question of jurisdiction. Are we in the right court? That's essentially the question that's going to be asked, is, are we in the right place? But the application to strike out our applications is done. So there's going to be a hearing. And that in my view, is a big step. As I've said before, given that there's these things going on in multiple provinces, with decisions coming in different directions in different places, it's likely that ultimately this ends up in front of the Supreme Court. So I think it's important that when it gets there, there's an evidentiary record. That's kind of my my take on this. That's kind of where all that is going. So anyway, feel free to ask questions in the comments below, but I'm going to be limited as to what I can sort of offer. I just wanted to give a heads up and an update as to what's happening here. This is going to be a well-fought issue. There's, able counsel on all sides and able sort of litigants on all sides. This is going to be a big, hotly contested issue. So I'll keep you posted kind of as things happen, but more to come, I guess, is the next thing there. Thank you for watching. I hope this has been interesting. I hope you've learned something. There are some things I wish I could say here, but I really can't because, again, ongoing litigation. But keep an eye out. This could be a really interesting case. I think there's no way that it's not a really interesting case at the end of the day. I hope I prevail, but I can't say I'm guaranteed to. But I'll keep you sort of posted along as I know things. I also want to thank my Patreon supporters who really help keep this channel alive, keep it growing. Sir Daniel Wicks of Alberta, Jason Elliott, D. Moe, Canada's National Firearms Association, North Central Process Service, Kyle Martin, and Jean-Guy Toussaint, all at the $50 level. At the $20 level, Dale Nesbitt, Cameron Johnson, and Andrew Elsich. And then Sights and Arms Limited at the $30 level. Also, a number of you at the $10 level who will be in the crawl immediately following. Thank you once again, and wish me luck, I guess, is the long and short of it. Until next time, I hope I've armed you with knowledge.